Bom dia a todos e a todas. Good morning. Welcome, everybody. We are starting this session, this first seminar or lecture or talk with Professor Brian Biggs. Thank you very much for being here with us this morning, Professor Biggs. Welcome to São Paulo, to our law school, to our group of legal theory, and actually we call it justice and law. And I would like first to thank Ariel, especially, but all the group of students and postdoctoral fellows of the school who have been organizing this session, actually the whole seminar this week, beginning with Ariel Peso, who is a postdoctoral fellow here at the Law School of São Paulo, Martin Petis, who is a doctoral candidate, several others I see here, Gilberto himself, who is a postdoctoral fellow, Danielle, Caio. I'd like to thank you for organizing this. I would like also to thank the commentators this morning, Rubens Glazer from Getúlio Vargas, who has been a doctoral student and actually has his PhD here from the University of São Paulo, and Gilberto, who is in Rio Grande do Sul, attending and taking part in this session also with us. And Gilberto is a postdoctoral fellow here at the University of São Paulo too. So I would like first to organize a session. We are going to listen first to Professor Biggs. Naturally, he's talking about lost claims today, which is a paper on the theory and jurisprudence of Joseph Ross. Everybody knows Ross here. We have organized an event, a seminary 2 years ago when he died. So this is going to be Professor Biggs' lecture. And then we're going to have some comments, some reactions from Gilberto, who's online, and then from Rubens. And then we'll probably take questions and commentaries from the audience. Okay, Professor Biggs is Professor of Law and Jurisprudence, the University of Minnesota in the United States. He's a well-known writer on legal theory and legal philosophy. I have known his papers for a long time, have read some of them, not all of them. He has a large bibliography production of papers and chapters in books. And of course, what he does is very interesting for us. He has published a very interesting book, which, if I'm not mistaken, has been published several times in several languages, including Portuguese. The book in English is called Jurisprudence, Theory and Context. It has been translated into Portuguese years ago by Gilberto Morbach, and it has also been translated in several other languages. I think it's, if I'm not mistaken, in the 9th edition already, right? And then he has a few other papers, lots of papers, but some which are very interesting for us, for our group, because he has dealt with, one of his books is called Law, Language, and Legal Determinacy. So we have a group here who's interested in the philosophy of language, the philosophy of action, the heritage, let's say, of Wittgenstein in law. And one of the chapters of this book, Law, Language, and Legal Determinacy, has been published in an anthology, a collection of papers by Dennis Patterson from Canada, isn't he? Canada? New Jersey. Oh, he published a lot in Canada, right? Yeah, that's what made me confused. Anyway, so this is Professor Biggs. We thank him again for taking the time, this long journey from the US to São Paulo. And we are very glad to have you here, Professor Biggs. Welcome. And you may take the floor.
Thank you very much for the very, very kind invitation, and I'm grateful for the wonderful hospitality, those who organized the visit, and for those who are taking time, Blazer, Dr. Moorbach, for all of you for taking time from your day to be here. One point, this is a sport coat. It's my sport coat. I just want to show you I own a sport coat. Now I'm going to take it off because it's really hot in this country. I was supposed to get really cold after I leave, but make that of that what you will. Also, one point, obviously I'm speaking in English. Everyone else is speaking English. And I know that's a wonderful, great indulgence that those of us from America and Britain and Australia and elsewhere don't sufficiently appreciate. So I'm grateful for that. I don't speak Portuguese, and I'm not very good at, I can speak a little bit of German, but we wouldn't get very far in that either. So I thank you for the indulgence to let me give this talk in English. This is a paper I presented, a version of it at Columbia. There was a conference in honor of the memory of Joseph Raz, and the proceedings of that conference and a few other papers will be published soon by Oxford University Press. But the paper contains many issues that I will return to again, have returned to, so your comments will be very useful, and I thank you in advance. Joseph Raz was my doctoral supervisor at Oxford, as he was for many. And like an even larger number, I attended his classes and listened to his conference presentations, and shared with an even larger number to this day, including many of you in this room. I'm a frequent reader of his books and articles and still struggle to understand his views and arguments. And following others who have written about Joseph's work and legacy, I believe that we best reflect what he was trying to teach through our own persistent questioning, indeed, perhaps especially the questioning of accepted truths, and certainly not excluding his own positions and arguments. In the present work, I fear that I have yet once again, I can still hear his quietly critical voice from discussions decades ago in his rooms. I've once again failed to live up to the standards Joseph wanted all of us to meet. However, with the help of the criticisms and suggestions by those of you today and from other readers, I hope to do better in the future. One central element of Raz's writings about the nature of law is his assertion that law necessarily claims moral authority. The present work will begin by critically examining Raz's claim, and will then use that topic as a starting point to explore basic questions about the nature of legal obligation. An important part of that exploration will be evaluating the possibility of thinking about legal normativity as sui generis, rather than as a type of normativity that needs to be reduced to or translated into some other type of norm or proposition. Oliver Wendell Holmes, the American judge and commentator, in his well-known article, The Path of the Law, argued for the importance of distinguishing law from morals, warning that, and here I'm quoting Holmes, "The law is full of phraseology drawn from morals, and by the mere force of language continually invites us to pass from one domain to the other without perceiving it, as we are sure to do unless we have the boundary constantly before our minds. The law talks about rights and duties and so forth, and nothing is easier, or I may say more common in legal reasoning, than to take those words in their moral sense." That's the end of the quote. Holmes was discussing a sort of unintended slippage from legal to moral. Despite Holmes's warning, there have been and still are many theorists who argue that legal content should be or must be understood in moral terms, at least as asserting moral content. These theorists argue variously that law should be understood as a subset of morality, or that law is a moral product of the action of legal officials, or that law makes moral claims. Regarding that last alternative, that law makes moral claims, Raz asserted that, quote, necessarily the law claims to have legitimate authority, and that claim is a moral claim, end of quote. Rawls elsewhere clarifies that by necessarily he means that, quote, the claim to authority is part of the nature of law, end of quote. What is the basis for this conclusion? Rawls offers the following argument. Here I'm quoting Rawls. The claims the law makes for itself are evident from the language it adopts and from the opinions expressed by its spokesmen, that is, by the institutions of law. The law's claims to authority is manifested by the fact that legal institutions are officially designated as authorities, by the fact that they regard themselves as having the right to impose obligations on their subjects, by their claims that their subjects owe them allegiance, and that their subjects ought to obey the law as it is required to be obeyed. End of quote. Rawls added, I'm quoting again, it, that is, law's claim, is a moral claim because of its content. It is a claim which includes the assertion of a right to grant rights and impose duties in matters affecting basic aspects of people's life and their interaction with one another. End of quote. Rawls elsewhere supports the idea of laws making a moral claim by analyzing the situation in terms of practical reasoning, regarding the way that law affects or purports to affect the reasoning of citizens. Rawls states, quoting again, the law has authority if the existence of a law requiring a certain action is a protected reason for performing that action. That is, a law is authoritative if its existence is a reason for conforming action and for excluding conflicting considerations. End of quote. This connects the understanding of the claims the law makes with Rawls's distinctive view that authorities give us exclusionary reasons. That under his view, law purports to give us both first-order reasons to act in a certain way and second-order reasons not to respond to certain other non-legal first-order reasons. In another work, Rawls offers an intriguing indirect argument for why we should view or characterize the statements of legal officials as moral claims. The argument begins by distinguishing the reasons one might give to justify one's own behavior, as against the reasons one would give in justifying the prescriptions for the behavior of other people. For one's own behavior, one can, and does, offer either moral or prudential arguments. However, when prescribing what other people should do, such prescriptions are generally based only on what those others purportedly have a moral obligation to do. Within a legal system, judges and other officials are often telling other people how they must act. Rawls comments, when judges, quote, accept a rule of recognition which requires them to accept other rules imposing obligations on other people, such a rule can only be accepted in good faith for moral reasons, end of quote. So by way of overview and summary, Rawls offered a series of justifications for the view that law makes moral claims, including the moral-sounding language law uses, the fact that authorities claim the right to impose obligations, the fact that officials claim that citizens should obey the rules, and the role legal rules play in practical reasoning and as protected reasons for acting as the law prescribes. In evaluating Rawls's claims, it may be useful to start first by looking at two threshold questions. Does it make sense to attribute claims to law? And second, how do we distinguish the claims of law from those of individual legal officials? And we should consider before reaching a third question, are law's claims moral or merely legal? One subtopic Rawls does not discuss, but which raises an issue in which a number of later commentators, both critics and supporters, have written, is whether it makes sense to say that the law claims, that it claims anything. But put the same point differently, is the law the sort of entity which can be said to make claims? The term law in English is notoriously ambiguous, which can be a burden for English language legal philosophers trying to be precise in their theorizing. When we use the term law, do we mean the concept law, the word law, a kind of social practice or social institution, a kind of practical reasoning, a kind of abstract entity, a particular rule, or some combination of these? When Rawls asserts that law by its nature makes a moral claim, by law he almost certainly means a legal system and its agents. Rawls is not here using the term in a sense of either more general or less general than that. On one side, it would not be easy to make sense of the claim that law, understood in its most abstract sense, makes a claim. Whatever the complications to be discussed in the moment of ascribing the power of claiming to a whole legal system, the difficulties would magnify if one thought of ascribing the power to claim to a general abstract category. At the other extreme, while someone might speak of the way individual rules make claims, such an assertion would merely be variations of the assertion that a particular legal system is, or that all legal systems are, individually making claims. Still, one might wonder what it means to assert that a legal system made up of multiple institutions and many individuals is claiming something, and claiming in some special way, that is, to make a moral claim. Some commentators have reacted strongly against characterizing law as claiming, stating that such characterizations are either category mistakes or unhelpful metaphors. The category mistake argument is that human beings claim, but institutions or abstract objects do not. For example, in a discussion responding to Rawls and also to Robert Alexi's argument that law claims correctness, Neil McCormick writes that the idea of law's claiming was, taken literally, a category mistake. And if taken as a metaphor, it's one that's unhelpful and potentially misleading. A legal system is a state of affairs, and states of affairs do not have intentions. Any claims to correctness for Alexi or to authority for Rawls is, he argues, that of a lawmaker, not that of the law. Ronald Dworkin's critique of Rawls's statement that law claims moral authority, which Dworkin includes in a kind of supplementary section to his review of a book by Jules Coleman, is similar. Dworkin asserts that stating that the law claims makes little sense as a personification of law, and additionally, he argues, seems also to be contrary to the legal positivist principles that Rawls elsewhere espouses. Dworkin writes, and here I'm quoting, "If we read Rawls's personification in this familiar way, we take him to mean that no proposition of law is true unless it successfully reports an exercise of legitimate authority. But that would imply not that morality cannot be a test of law, as Rawls claims, but that it must be a test for law, because, as he recognizes, no exercise of authority is legitimate if the moral or normative conditions for one's directives, being authoritative, are absent." By contrast, at the end of quote, by contrast, in supporting Rawls's position, John Gardner asserts that it is the nature of legal officials, that it is part of what it means to be a legal official, that these individuals make claims in the name of their legal system. And taking a similar view, Robert Alexi concedes that, in a strict sense, claims can only be made by lawmakers, not by the law itself. However, Alexi goes on to argue that actors in the legal system, individuals making claims as well as judges adjudicating them, use the notion of laws claiming in the process of determining what the law requires. It's good to have a sort of a backbeat when you're talking, like a boombox. While individual human beings are the usual agents to whom we ascribe claims and similar linguistic actions, we are also now accustomed to seeing claims ascribed to other sorts of entities, including institutions and other collectivities. We hear about the claims of government, unions, corporations, advocacy organizations, just to name some obvious examples. To the extent that we become comfortable with the ascription of claims to these entities, it is not evidence why we should draw the line at not making comparable ascriptions to legal systems. This is not the occasion for developing a full theory of collective or institutional agency. There is clearly difficult work that needs to be done analyzing under what circumstances, actions, and intentions can appropriately be attributed to such entities. It is sufficient for present purposes that in a number of other contexts, we take ascriptions of views to institutions or groups as not being necessarily a category mistake, and at least presumptively something more than a mere metaphor. For present, I must leave the issue at that in order to move on to other issues. As discussed, one common way to understand the assertion that law claims something is to equate that assertion with the statements and decisions of individual legal officials. That move removes some of the strangeness from the characterization. However, it does so at a cost. If the claims of law are simply whatever certain legal officials state or do, to which legal officials are we referring? The seemingly obvious reference would be judges, but there are other legal officials who also seem to make authoritative claims about what the law requires and permits. One notes the cliched declarations of police officers in films and television shows: stop in the name of the law. Many legal officials claim to be speaking on behalf of the law, or at least give that appearance. Police officers, clerks in the property office, officials in administrative agencies, amongst many others, along with judges. They all give prescriptions, prohibitions, and permissions that purport to reflect the view of the legal system. There are complications, however, which make one hesitate to equate the statements and decisions of any and all individual legal officials with those of the law. First, one must, of course, inquire whether the official in questions were acting in or within their legal authority. Judges and police officers or the heads of administrative agencies making comments during a social dinner after work hours would likely not be held to have made claims on law's behalf. There are also harder cases. For example, consider situations when the officials purport to act in their official capacity, but in fact are acting beyond or outside that capacity, acting, as they say, ultra vires. In such cases, the statements, actions, or decisions, though technically ultra vires under the rules accepted at the time, might nonetheless go on to be treated by others as valid, and any resulting rule might become settled law. In some situations, whatever the officials were speaking for the law is not clear at the time of their decision and may only become clear long after the event in question. Actually, I'll return to issues along these lines in my third lecture on Friday. Conversely, a statement or decision made on behalf of the law, even when clearly made by an official in her official capacity and within her delegated powers, may in due course be overturned by an official or institution higher in authority. In such cases, the original decision purported to state the law's views, but the message of the reversing court or official is that the original decision, in fact, misstated the law's position. Both the decisions that are or might be ultra vires and the decisions that are later overruled and raise issues of legal mistake, again, which we'll talk about on Friday, or perhaps even change in the rule of recognition. Topics of obvious practical and theoretical importance, but I will have no time to discuss these issues today. What this discussion does indicate is that assuming that the law claims, the exact content of its claims will sometimes be uncertain, given the potentially conflicting voices amongst its officials and the potential defeasibility of those claims. In general, law's claims, law's views on certain matters cannot be in any simple way reduced or equated with the particular views or actions of individual legal officials. Assuming that it makes sense to ascribe claims to law, what kind of claims does law make? What kind of reasons does law give us? Here, we need to take a short digression to more general topics regarding reasons. According to some theorists, reasons differ in part according to their substantive context. Depending on their origin and justification, there are moral reasons, religious reasons, and legal reasons. There are also etiquette reasons and chess reasons, as well as reasons of many other kinds. There are, as it were, many sorts of normativities, many sorts of oughts. These different reasons will inevitably conflict in our lives, and when they do, the agent must decide which set of reasons to follow. Some commentators urge that many such conflicts will be easy to resolve because morality arguably gives us real or robust reasons, while etiquette and games generally give us, it said, formal or superficial reasons. If morality requires conflicts with what etiquette or some board game requires, most of the time one should simply do what morality requires. In other cases, though, the conflicts may seem to be a more careful consideration of the number and weight and kind of reasons on each side of some question. That, for example, when we have a moral reason to obey or to disobey the law may be a complex question depending on many factors. According to some theorists, the discussion of different kinds of reasons is misleading. There are only reasons, not subdivided into categories. Under this approach, reasons are to be distinguished only according to their strength, or perhaps whether they operate in a first order or second order manner. Under this approach, some purported reasons might be dismissed as not real reasons. As this work indicates, I'm inclined towards the first perspective with its plurality of reasons, though I recognize that many other theorists favor the second. It is now common amongst legal theorists to argue that law purports to be some other type of normative claim, or to equate legal obligation with some other normative or factual discourse. For Rawls and for others, law makes moral claims. For Mark Greenberg, law is a subset of morality. And for the American legal realists, law is generally understood as a prediction of official action. The present text suggests an alternative approach, one under which the claims that law makes are not to be equated with or reduced to another form of discourse. Rather, they are what they appear to be and nothing more, simply legal claims, just as morality makes moral claims and etiquette makes etiquette claims. While the idea that law makes only legal claims might at one level seem obvious, among legal theorists it will be controversial, and some will say it's obviously mistaken. John Gardner offers what at first glance appears to be a simple and ingenious proof that law does not make legal claims, but must be making claims of some other kind. His analysis begins with the point that claims, as claims, must be fallible. To make a claim is to make an assertion about the world in some way, which as an assertion must be capable of being true or false. However, Gardner continues, law cannot be simply mistaken regarding legal claims. So if law is making claims, they must be making claims of some other kind, likely, he thinks, moral claims. However, there is a response to Gardner, and it focuses on the key point about fallibility. Consider the analogy of the divine command theory of morality. According to that theory, God's commands constitute what counts as morally true. Morality simply is God's orders, no more and no less. If one adopted this approach, and the present work takes no position on its merits, one would not say that God makes claims about what is morally true. Rather, divine prescriptions constitute what is morally true. The analysis of law and legal claims is similar. What the legal system collectively says about some subject, that constitutes legal truth for that legal system. Under this analysis, it would be misleading, or at least unhelpful, to say that the law is claiming legal truth. However, as discussed above, one might offer that description, making a claim about legal truth, for the actions and statements of individual legal officials. Individual legal actors can make mistakes and can be overruled by higher legal officials. It captures something of that subject to change, subject to correction, the feasible nature of any official's actions and statements, to characterize them as mere claims to legal truth. When we say that the assertions of the legal system as a whole constitute legal truth, we mean something like the relatively settled view of legal officials collectively. That point likely warrants further discussion and will require further clarification. But again, this must await another occasion. And again, we'll talk about it more on Friday. The idea that legal officials claim legal truths regarding legal obligations is thus, contra Gardner, conceptually possible and coherent. However, it still requires some explanation. The basic idea, as already indicated, is that law should not be understood as making a claim about morality or some other type of discourse, nor should legal propositions be understood as simply a shorthand for predictions about empirical matters. Rather, law is to be understood as a sui generis form of normativity, its own form. This is not an entirely novel view. One could find it or something like it in scattered comments amongst figures as central to contemporary legal philosophy as H.L.A. Hart, John Finnis, and Matthew Kramer. As already mentioned, the suggested view is simultaneously seemingly a simple and common sense view, and at the same time, at least in some circles, a radical and strange idea. One can explain the basic notion in various ways. That what the law provides us with are legal reasons, and that the meaning and explanation of terms like legal obligation and legal right will come in some significant part from within legal discourse, from other legal terms and concepts, and not to be defined entirely from terms and concepts of other normative systems or other areas of discourse. The alternatives to reduce or translate legal propositions and claims into different sort of discourse, moral or factual, have problems, some of them well known. Earlier parts of the present work have mentioned some of these problems with viewing law as making a moral claim or being subject to this, or being some subset of morality. Most obviously, such an equation seems contrary to foundational observations or experience that law and morality often diverge sharply. Law may require or authorize immoral actions. Morality may require or authorize illegal actions, and so on. And while the matter remains controversial, there are substantial reasons to conclude that there is no presumptive moral obligation to obey the law even in generally just legal systems. No other things being equal obligation to do what the law says simply because the law says so. On the empirical alternative, the idea of reducing legal propositions to or equating legal propositions with certain factual descriptions or predictions is well known from the works of the American and Scandinavian legal realists, amongst others. Oliver Wendell Holmes, mentioned earlier, famously wrote, quote, "The prophecies of what the courts will do in fact and nothing more pretentious are what I mean by law," end of quote. Putting aside whether Holmes intended that quotation as a conceptual definition, as contrasted with being just advice to young lawyers, the possibility of understanding law in terms of past, present, or future official actions is an option seriously to be considered. It has been discussed as a worthy alternative approach, to the nature of legal facts by important contemporary theorists, including Jules Coleman, Brian Leiter, and Connie Rosati. However, equating law with what judges in particular or officials generally have decided or are likely to decide is in tension with the common practice, common amongst lawyers and average citizens as well as law professors, of criticizing court decisions as wrong about what the law requires. Decisions interpreting and applying constitutional provisions, statutes, and prior court decisions. Criticism offered sometimes even when those decisions reflect the view of a majority of legal officials, and even when decisions are those of the legal system's highest court. That is, our practices reveal that it is conceptually coherent to think that the view about the law is wrong, even when it is the view held by a majority of judges and even a majority of the judges on the highest court. And in general, explaining legal facts or legal claims as being about what legal officials have done or what they will do leaves it hard to explain what the judges themselves are doing, or to guide them towards what they should be doing. It's quite possible that some lower court judges may be focused on predicting what the higher courts will do, what decisions are likely to be upheld on appeal rather than overturned. But that explanation will not be applicable when one is talking about the decisions made by the judges on the highest courts. As H.L.A. Hart argued, there may be a worldly truth, but also a deep falsity in saying that the law is simply what the judges say it is. Hart explained his view through a hypothetical game of scorer's discretion. Sports fans who think that their team are harmed by bad officiating might claim that the rule in the game seemed to be simply that a goal is scored whenever the referee says it is. But a game where that in fact was the only rule about scoring would be absurd and senseless. However incompetent they may be at times in doing so, referees purport to be applying an established scoring rule. And just as referees purport to be applying standards independent of them, so do judges. In her response to an earlier piece, which introduced some of the ideas more fully developed in this piece, Connie Rosati raised questions about whether H.L.A. Hart, or the sui generis legal normativity I attribute to him, adequately explains the normativity of law. Rosati refers to my attributing the sui generis position to Hart and comments, quoting Rosati here, "We seem to learn from Hart only what it is for officials and some others to treat the law as normative, not what it is for the law itself to be normative," end of quote. Here Rosati is focusing on a much discussed problem in Hart's analysis. Hart had importantly, and in the view of most readers, persuasively criticized the earlier command theory of law presented by John Austin as being more than the gunman's situation writ large. In his book, The Concept of Law, Hart urges theorists to incorporate the perspective of those who accept the law, who view the law as giving them reasons for action. However, as John Finnis and others have pointed out, this leaves the normativity of law at an unhelpful distance. The theorist is observing that some legal subjects are treating the prescriptions of legal officials in a normative manner. But Hart precludes the theorist from inquiring further as to why the subjects are doing so and whether they are justified in doing so. Finnis argues that we should not just incorporate the view of subjects who view the law as giving them reasons for action. We should inquire whether they are right in doing so. Returning to Rosati's critique, if the question is whether Hart's view, or my view, adequately explains the law's normativity, the natural focus turns to what law's normativity and its explanation entails. The threshold difficulty is that what it is for law to be normative is itself far from clear and is highly contested. This touches on matters that have been central to this work throughout. There are various ways in which the law is, or is seen to be, or purports to be normative, and normative both in the sense of action guiding and in the different but overlapping sense of evaluative. Some would point to the way that law attempts to guide citizen behavior, and also in both applying and following the law to guide the behavior of officials. Additionally, law uses the moral-sounding language of duty and right and permission. David Enoch has argued that there is no special sense of normativity that a theory of law needs to explain, nothing different than the formal normativity comparable to what one finds in etiquette or fashion. And the fact that law has great significance in our lives does not change that. Enoch writes, here I'm quoted, "I agree that the law is especially important in many ways. I also agree that the law's importance merits interest in it, philosophical among others. But the law is not special or significant in ways that are relative to formal normativity. If the law is special, it is because it is powerful. That is not related in an interesting way to the law's having correctness conditions. Vis-a-vis its formal normativity, the law is not special." End of quote. As Rosati points out, it is common to compare law to a quite different normative enterprise, games. Quite frequently, the game of chess. As she observes, with chess one can speak about standards which determine what counts as playing the game, as well as objectives of the games and what counts as winning the game. The prudential, moral, and other reasons for and against playing the game are independent of, separate from, the norms that govern the playing of chess. Thus, there is a kind of normativity within the practice. What constitutes the practice, or criteria of success or excellence for participants, and so on, that leaves open the possibility, A, of not taking up the practice at all, or B, relatedly, judging the value of taking up the practice, or in general, or by a particular person at a particular time. Do we have the same sort of choice about taking up law that we do about taking up chess? Where a legal system is generally effective, one may be unable to escape its threatened coercion and other factors that may enter into prudential calculations. But that still differs from the sort of questions raised earlier in the work about law's claims and about the nature of legal normativity. In her commentary, Rosati presses me to be more responsive to the question whether law itself is normative and what its normativity consists in, suggesting that this might be explored through, for example, these more specific inquiries. Do officials and some citizens see or view the law as giving them reasons? What sort of reasons do they view the law as giving them? Does the law actually give them reasons? And what sort of reasons does it actually give them? Rosati encourages a focus either on the reasons subjects perceive the law as giving them or on the reasons law actually provides. As regards the first, what reasons people perceive the law as giving them, I see that as a question more for psychology and sociology, though of course with implications for legal philosophy. For example, Frederick Schauer argues that H.L.A. Hart was wrong to build his theory of the nature of law around those who accept the law as giving them, that is, who take the internal point of view, given that most people, Schauer argues, obey the law primarily for prudential reasons, to avoid sanctions. The answer to what reasons the law actually gives would be similar to that offered by John Finnis when he was pressed to give content to the concept of legally obligatory. Because of its relevance and nuance, I quote Finnis's response at some length. Beginning of the quote. The law implicitly deploys and holds out the schema of practical reasoning such that it makes no reference to the common good, but just to an unspecified need for all the laws subject to be law-abiding. That need in turn can be explicated by good citizens in terms of the common good, by good citizens, unquote, uncritical servants of the regime in terms of sustaining the regime, by careerists in the law in terms of what must be done or omitted to promote their own advancement towards wealth or office, and by disaffected or criminally opportunistic citizens in terms of what they themselves need in order to get by without undesired consequences. In all these specimens of practical reasoning, the law slots into relevant schema and therefore intelligibly holds out its principles and rules as non-optional standard for comparing options and ranking them as obligatory, permissible, or impermissible, and so forth. That is the place it claims in our deliberations. When natural law and natural rights predicates of those non-optional standards that they are legally obligatory in the legal sense, a sense in which their obligatoriness is deemed invariant, conclusive, non-feasible, peremptory, as distinct from legally obligatory in the moral sense, a sense in which their obligatoriness is presumptive, defeasible, and so forth. Whatever the practical reasoning into which it slots, the law schema for practically understanding the legal obligations the law claims to articulate and impose is one and the same, practical but not in itself as such moral, though in the central case also apt for a moral reading by morally concerned subjects, yet far from empty of guidance as non-optional for those uninterested in moral concerns. End of quote. Some readers might find it interesting that an author who is critical of H.L.A. Hart for accepting a variety of motivations for subjects taking up an internal point of view towards law would seem content to incorporate into his understanding of legally obligatory a variety of motivations for the use of law within practical reasoning. Finnis's view appears to be that the central case or focal meaning of law need not be one of moral claims, or even the consistent, defeasible creation of new moral reasons. The position being suggested by the present work is that legal obligation should not be understood as a general, robust moral obligation, which differs from other moral obligations only that its origin is in the actions and products of legal officials. Rather, legal obligation is a different type of obligation, creating different types of reasons. Hart writes in the concept of law that, quote, law's existence means that certain kinds of human conduct are no longer optional, but in some sense obligatory, end of quote. Those inclined to view law as making moral claims and creating moral reasons and want to cite Hart in support of that will emphasize the obligatory in that sense. Those who prefer an alternative understanding may emphasize the ambiguous qualifier in some sense. Of course, determining the intended meaning of any such stray sentences may be important in understanding Hart's intentions and how they may have changed between the concept of law and certain portions of Essays on Bentham. In Essays on Bentham, Hart writes, here I'm quoting, "Judges, in speaking of the subject's legal duty, may mean to speak in a technically confined way, but they speak as judges from within a legal institution from which they are committed as judges to maintain in order to draw attention to what by way of action is owed by the subject, that is, may legally be demanded or exacted from him. Judges may combine with this moral judgment and exhortation, especially when they approve of the content of specific laws. But this is not a necessary implication of the statement of the subject's legal duty." End of quote. In any event, the primary task of the present work is not Hartian exegesis, but rather exploring the tenability of a particular view of legal normativity and legal obligation, regardless of whether or in which text it may reflect Hart's views. The question remains, what sort of reasons does law give us under the suggested approach? And the proposed answer is, in quite abstract terms, the same sort of reason one gets from etiquette or fashion, a social club, or a board game. Legal reasons generally carry more motivational weight for most people most of the time, compared to, say, etiquette or fashion. But that is because, at least in generally effective legal system, the threat of legal sanctions, and occasionally of legal rewards, evokes prudential reasons for compliance. And those prudential reasons are generally motivationally stronger than the social pressure brought to bear by etiquette or fashion. As Joseph Raz elsewhere points out, law sometimes does give citizens moral reasons due to its being a salient coordinator or because of the greater expertise of lawmakers. And as David Enoch has argued, law may sometimes trigger our existing moral duties. But beyond those situations, law may obligate, to quote Michael Moore, only in the Pickwickian sense that law gives rise to liability to sanctions, and the liability induces habits of obedience in citizens, and perhaps even beliefs in legitimacy. At the same time, to say that legal normativity is sui generis is to insist that legal obligation is not fully equivalent with facts about past, present, or future official actions, and that one can sensibly speak about having a legal right or legal duty, even if enforcement through the courts is not available. In all, the view of law as a sui generis form of normativity, a formal normativity comparable to other formal normativities, seems sustainable and explains many practices and attitudes better than viewing law as a subset of morality or as making moral claims on the one hand, or viewing law as the prediction of official action on the other hand. One objection is that there is another significant difference between law and, say, etiquette and board games that the analysis needs to take more seriously. This objection emphasizes that there are moral reasons for creating and maintaining a legal system, reasons far more substantial than any reasons one might have to create or maintain a system of etiquette, a social club, or a game. One can concede the point, yet still wonder if this changes the conclusion about the nature of the normativity one finds in law. In Enoch's point, recall that law may be significant, including have morally significant consequences in the world, without its being normatively distinctive. There is one other alternative viewpoint to note, even if this is not the occasion to explore it sufficiently. It is a middle position associated in different ways both with David Deisenhouse and in a prior generation, Lon Fuller. Both Deisenhouse and Fuller argue in distinct but overlapping ways that law has its own internal morality. Each author asserts that there is a morality within law, beyond what standards might be imposed from outside, from conventional non-legal morality. For those two theorists, the value of legality is both distinctive and morally positive. However, considering such views, we should also keep in mind those theorists who portray legality as distinctive, but a less clearly positive attribute. Leslie Green and Thomas Adams write, "A musical fugue may be at its best when it has all the virtues of fugacity, but law is not when it excels in legality. Law must also be just. A society may therefore suffer not only from too little of the rule of law, but also from too much." End of quote. And consider also the famous words of Grant Gilmore, quoting Gilmore. Law reflects, but in no sense determines, the moral worth of a society. The values of a reasonably just society will reflect themselves in a reasonably just law. The better the society, the less law there will be. In heaven, there will be no law, and the lion will lie down with the lamb. The values of an unjust society will reflect themselves in an unjust law. The worse the society, the more law there will be. In hell, there will be nothing but law, and due process will be meticulously observed. End of quote. From Green and Adams and Gilmore, one gets a sketch of legality as being of significance, but of uncertain and perhaps fluctuating moral weight. By way of conclusion, for Rawls, law by its nature claims to be a moral authority, though, as he argued elsewhere, law often fails to justify that claim. There is an obvious attraction to Rawls's position. It seems to make sense of legal officials telling us what to do, and many individuals seeming to believe that they should do what the law says just because the law says so, even without consideration of sanctions. This work is considered, albeit briefly, why some theorists are troubled by the assertion that law claims, that it claims anything. Troubled because the law may not seem to be the sort of thing that should be said to be making claims. This concern should not be lightly dismissed, but it was also pointed out that we attribute claims or actions to other abstract or collective bodies, so perhaps the idea of law's claim should not concern us unduly. The challenge raised in the present work has been focused more on the attitude that legal propositions must be understood in terms either of morality on the one hand or empirical predictions of official action on the other. The alternative presented here to Rawls's view that law purports to be making moral claims is one in which the law is seen as a sui generis form of normativity, that legal rules create legal obligations and give us legal reasons to act or not act in specified ways. This alternative faces its own set of challenges, to be sure. Can be part of an adequate explanation of legal guidance, where citizens sometimes, perhaps often, act as they do because the law says so, and when judges impose significant sanction on parties who act contrary to law. Legal obligations, of course, may be just the shorthand of powerful groups imposing the will on the less powerful. But that view is not persuasive to everyone, and certainly not to all legal officials, or indeed to all legal theorists. Thank you.
Thank you very much, Professor Brian Biggs, for a very illuminating lecture or lesson on the discussion of essential legal problems and concepts in various authors of our age. I would like now to give the floor to Gilberto for his comments. Let's say each one of the commentators maybe could speak for 20 minutes or something like that. Would that be okay? Okay. Okay, Gilberto. So I have to introduce Gilberto. Gilberto is a postdoctoral fellow at the University of São Paulo. He got his PhD in Rio Grande do Sul at Unicinos, and he has already written several papers, organized a few books, including a recent one with Danielle, who's here present with us. And he has written a book on the third way of Waldron, Waldron's third way, a terceira via de Waldron. And he has one book in press now on the concept of law and the concept of rule of law, Estado de Direito, Conceito de Direito. So we're very glad to have him here with us today, this morning. Unfortunately, as everyone here in Brazil knows, Rio Grande do Sul has been kind of insulated from us after the floods in May. So he could not be here presently with us. The airport's not working in Rio Grande do Sul, in Porto Alegre. So he's joining us online. Thank you very much, Roberto. You may take the floor.
Thank you, Professor José Reinaldo. Thank you, Professor Brian Biggs, for such an insightful, clear, and beautifully written paper, I should say. I will try my best to be as brief as I can here, and I would like of course, to apologize for not being there in person. Professor José Reinaldo has already stated my reasons. I hope you can all hear me well, and please let me know if there's anything wrong with the connection or with the sound or anything like that. I would also like to thank Ariel for organizing the event, Martin, Danielle, for such an invaluable work you've been doing for the department. And I'd like to start my comment. First of all, I'd like to compliment Professor Brian for he sure did honor Raz's legacy of persistent questioning. This is something that I see in all of his works, all of his papers, his books. I really see this capacity, this ability to reconstruct theories and debates and ideas without ever taking anything for granted. So this is something that really is distinctive of Professor Brian's theorizing. So I will try my best here today to honor Raz's legacy as well. So I will bring up some questions for Professor Brian and also his teachings, because I learned a lot with him with this idea of persistent questioning. So like I said, I will try to be very brief. I think the talk itself was already very illuminating, but I would like Professor Bix actually to develop a couple of points I will bring up here. These 2 points are actually very closely related to each other. The first one is, I will first state very briefly the 2 points I'd like to make, and then I will elaborate on them in the 20 minutes I have. The first point will be the following, something along these lines. You know, though the paper carefully reconstructs, like I said, several arguments in favor of lawmaking a moral claim, I'll be criticizing them in a little bit. I would like Professor Bix to respond to one argument that the paper does not mention and that I will bring up here, which is namely Gerald Postma's argument in his paper called Norms, Reasons, and the Law. The second point I will try to make is I will attempt to insist on a point made by Gardner, which Professor Bix has responded to, and ask for Professor Brian to actually expand his corresponding counter-argument, bearing Postma's arguments in mind too. So I will try to supplement some of Gardner's points with some arguments developed by Gerald Postma, and then after I bring these arguments together, I'll try to round them all up. I'll ask Professor Bix to comment on them. So first, regarding Postma, I would like to bring up here the following passages by Postma in defense of this idea of lawmaking moral claims. In this paper I mentioned, which is called Norms, Reasons, and the Law, Postma starts quoting Raz, and he quotes the following passage by Raz. While one can accept law as a guide for one's own behavior for reasons of one's own personal preferences, I know Professor Bix has touched upon this in his paper, or of self-interest, one cannot adduce one's preferences or one's self-interest by themselves as justification for holding that other people must or have a duty to act in a certain way. So Postma retrieves this passage by Raz, and then he follows. Now Postma follows. Legal rules, Postma says, have a twofold function. They guide action and they provide a framework for public justification of actions. Thus, the argument continues, officials who accept legal rules must believe that they are at least minimally capable of performing these functions. They must believe then, or at least of all, that the rules they appeal to justify the duties to which citizens are held and justify their holding citizens to those duties. However, mere conformism or personal self-interest could never ground such justification. Only recognizable moral reasons could hope to do the job. I know Professor Bix has touched upon this in his paper, but then later in the paper, Postma elaborates. He says, Raz maintains that in cases where officials do not actually accept the system for moral reasons, they must nevertheless pretend or avow the moral justification of the system itself, because the law claims such justification. And here's what's interesting, and which is directly related to one of the elements that are present in Professor Brian's paper. Postma says, the law's claim cannot be simply reduced to the claimings or beliefs of individual officials. We must not confuse the attitudes and beliefs of particular judges with implicit claims of the law. The claim is made from the point of view of the law. This is indeed a theoretical construct, not the point of view of any actual person, any more than there is a reasonable person in tort or in criminal law, Postma says. And here is his point. There is nothing mysterious about talk of law's claims. The claims are attributed to the law in an attempt to account for important and enduring features of legal practice and legal discourse. The thesis that law claims moral authority seeks to account for the fact that officials typically put forward and are taken to put forward their appeals to legal norms as justifications to those affected by their decisions and to those who hold them accountable for their official decisions and actions. And this is what's more interesting, I think, and more novel in what Postma says in relation to those arguments that Professor Brian has already considered. This is an assertion about the practical point and value of legal practice, not about people's beliefs about that practice. Because law, Postma says, is meant to be, I think this is important, this is a nuance that is important. Law is meant to be not a matter of personal rules for private behavior, but a matter of public common standards. These are some of the passages I'd like Professor Biggs to have in mind that are put forward by Postma in his paper. But now, before stating more clearly exactly, which is exactly my question, let me raise the Gardner point first. With all of this in mind, of course. I understand that Professor Brian rejects Gardner's idea that the law, and therefore legal officials, in his understanding, in Gardner's understanding of law's ability to claim, that law cannot by definition make legal claims, for claims must be either true or false. I think Professor Biggs is rather persuasive in saying that officials can make legal claims about legal propositions because they can be wrong about it. So Gardner would not be defeating the argument that law cannot make legal claims. However, I believe Gardner's point, especially if we supplement it with Postma's account, runs a bit deeper. So my question would be something like this. Is it not possible, Professor Brian, to accept your argument about legal claims, but about specific legal propositions, and yet maintain that the authority of law itself, as such, law as a practice, rests and depends on a claim that can only be moral? I mean, legal propositions can make legal claims, but the law, for it to be intelligible, needs to make a moral claim. It can only be a moral claim. In other words, officials can perhaps claim legal truth, but their authority to do so depends itself on an underlying claim to legitimacy, which can only be moral. Perhaps the wording here can be slightly unusual without context, but I think Postma's point helps us to understand that moral legitimacy is what makes legal claims intelligible as such, as legal claims, what gives them meaning. I must add, I owe this idea of intelligibility and meaning here to Professor José Reinaldo, who is actually an intellectual hero of mine. So still, if this is not the case, I mean, if we accept that there is no ultimate claim to legitimacy to law itself that can confer its meaning and its ultimate authority, I think all we have in the end is Professor Brian's closing remark. And then legal obligations in the end are just the shorthand of powerful groups imposing their will. I know Professor has said that this is not a scenario that appeals to most legal scholars, but still, in short, to turn all of it, all of these insights by Postma and this attempt to retrieve some of Gardner's account and explanation, my question, Professor Brian, would be the following. Even if officials can claim legal truth, and even if the normativity of specific legal propositions is legal, sui generis, can we make sense of law as a distinctive mode of governance without the idea of a claim to moral legitimacy by law itself and not its specific legal propositions? This would be my main question I would like to direct to you, Professor Brian. Still, like I said, it's my attempt to honor Raz's legacy of persistent questioning. I have enjoyed the paper very much, and it's been very challenging to some of my already formed beliefs about law and about legal practice and about legal theory in general. I would also like to add, finally, that I appreciate in the beginning that Professor José Reinaldo mentioned my translation of your book. It's been, I must add, very well received here in Brazil. It's a textbook that it has been incorporated in the reference list for many courses in jurisprudence and many specific disciplines in the Department of Law here at USP as well. So thank you for this. Thank you for the opportunity. And of course, thank you for taking the trip and the time to discuss with us here in Brazil. It is an absolute honor for us in Professor José Reinaldo's group, and I'm sure for the whole community at USP as well. I hope you're having a great time, and thank you for this. If there was anything that wasn't clear in my question, I am, of course, available to try to make it clearer, but this overall would be my attempt to honor your teaching of persistent questioning, and this is the question I direct to you then. Thank you very much indeed.
Thank you, Gilberto. I was thinking that maybe we could listen to Rubens, if you have taken note of the questions of Gilberto. Well, okay. So yeah, okay. So we'll have the comments of Rubens. Rubens is a professor of constitutional law and public law theory at Fundação Getúlio Vargas here in São Paulo, and he got his PhD here at USP under my supervision, thinking and writing on Joseph Ross's legacy and idea of law and law and practical reasoning. So again, thanks a lot, Rubens, for being here with us this morning. You may take the floor.
Okay, thank you all. It's been an honor to be here. Professor Brian Bick's books and all his bibliography are very useful, object of admiration. They carry the virtues of clarity, intellectual honesty that are much needed in legal theory and law in general. And thank you to all the organization. And I'll start by saying that I'm in an uncomfortable spot because I am not a Razian, and I'm trying to offer what would be Raz's reply to an expert on Raz. So, and right before lunch, so please be patient. Okay, I have one point. My point is that I consider to be misleading to say that according to Raz, law makes moral claims. Raz says, and the paper points correctly, that law claims legitimate authority, and that claim has a moral nature. I think that we should not collapse that into saying that law makes moral claims, because that can be misleading in a specific way. It can make it appear that Raz uses the idea of law claims as equivalent to the specific content of legal propositions on rights and duties. And I believe that is not the case. Right in the beginning of between authority and interpretation, Raz says that law presents itself as answerable to moral standards, as if it had reconciled politics and morality. How he likes to say on other papers, law acts on the guise of the good, sob o disfarce do bem. So, what is the claim of law? I will try to sum up like the speech act of legal institutions and of public officials that carry this kind of implicit presupposition that they are not arbitrary, arbitrary, sorry, but actions that are answerable to these moral standards. They can fail, they often fail to live up to that expectation, but it is just this kind of implicit presupposition. Even if they are mistaken, even if they have ultra-virus defects, even they are out of mandate, when they act in such a way, carrying this kind of presupposition. That is not a good word because of the implication of how Kelsen uses the presupposed nature of the Grundnorm.
We'll get to Kelsen on Wednesday.
Okay, but
Don't worry.
differently from Kelsen, uses presupposition to sign the normativity. And Raz is doing just the opposite. It's just a synonym without normativity. And I believe that law claim being just this kind of implicit presupposition, that is why it's not dependent on the specific intention, state of mind of legislators, judges, etc., as pointed out by Gilberto and Postema. Especially because I don't think that Raz is making an empirical argument about how public officials behave. I think, and he does not use this phraseology, but use the act of officials in an approach of phenomenology. And he uses a lot of that approach since practical reasons and norms when he's thinking about authority. I think it is in Facing Up, a reply when he says that a philosopher should see what the actors are doing, what they think they're doing, and using not conceptual analysis, but he can give a conception of what they are really doing and saying, you think you're doing this, but in fact you're doing that. And I think that is the whole nature of his approach. I think what he's trying to say is, how can we make sense of public officials arresting, fining, declaring bankruptcy, declaring debt, deciding if a kid will live with their mom or their dad in a divorce situation? All these are serious questions that are not presented as arbitrary actions, as acts of vengeance, as acts of power. They carry this assumption as if they are answerable to moral standards. They are rational, legitimate use of power. And that's why loss claims is a way of explaining what the agents are making, independent of what they are actually feeling, thinking, etc. If it was empirical, it would rightly collapse into a Homesian argument and be subject to the Hardian objection of the scholar's discretion. So my modest point is, if I'm right, the loss claim has no connection to the content of specific legal propositions, declaring rights and duties, or of public officials' specific intentions. It is an explanation that since the system is presented and acted upon as not arbitrary, it carries the disguise, this as-if attitude of legitimate authority that frequently it doesn't have. Okay? That is why I think that Raz would have no problem agreeing with this Brian Bick's depiction of the amoral nature of legal obligations on page 22 of the paper. The position being suggested by the present work is that legal obligation should not be understood as a general, robust, moral obligation. I think that Raz would be fine by that. I think that most of the discussion of the authority of law regarding the legal point of view would say that if I want to ascertain, if I want to find out what are the specific duties, and obligations. I should not use moral. I should use reports to what the law says. But there is a separate question. The question is not what the law says. The question is, are those real obligations? Are there real reasons to conform to that obligations, or is this the situation of the gunman written large, etc., etc.? The subject perceptions do not answer that. That's correct. That's a matter of the efficiency of the de facto authority. De facto authority is largely based upon how the subjects feel, react, or perceive the exercise of force or power. But the question of if there are real reasons, if that is an authority that should be complied with, that is another question. It's the question of the presence or absence of legitimate authority. A presence that the phenomenology of legal discourse, how laws are written, how elected officials perform their acts, legal notifications, etc., carry. Since I have time available, why the normativity of law is different than games? Personally, I believe it's not. I believe they both report to a point that is internal to the practice. But I believe the RAS do a lengthy discussion of this by the end of Practical Reasons and Norms, when he's discussing Searle's constitutive and regulative rules. And he says something about that games are an artificial practice that are not connected to external values. So if you engage in a game, you have reason to act according to its rules. And these are reasons that are all internal to the game. But he says, law, it's the game, the system that complies all other social practices. And it's connected to political values such as liberty, equality, etc., and etc. And that's why looking just internally to legal practice cannot give real reasons. They are dependent on this robust moral considerations. That is my presumptuous pointing to an expert on RAS about how an anti-Rasian would read RAS. Thank you very much.
Thank you, Rubens. So, Professor Bix, for your reactions. Thanks a lot.
First and foremost, I'm deeply grateful to you and to Gilberto for taking the time and the attention, giving a very careful reading my modest piece, which reminds me of a criticism I need to pass on to Gilberto, which will not be new to him. That he's a wonderful young scholar, but he shows poor judgment, and that he spent all this time translating my work when clearly the far better use would be to have spent the time on his own work. He seems to be catching up quickly, but still poor judgment. But he'll get over it. Let me deal with some. I think deal with Ruben's comments will help me transition and make similar responses to Gilberto. First off, as I said in my paper, I wasn't trying to offer a paper on heart exegesis. On Wednesday, you'll see I'll spend a lot of time say that I'm not trying to do Kelsen exegesis. I'm spending a lot of time telling you what I'm not doing, which seems a strange practice. And if I haven't quite gotten Ra's exegesis right, that's fine. This is not meant primarily as an interpretive work, more as an entree into the question which both you and Gilberto get to, of what is the nature of legal obligation, what's the nature of legal normativity, what's the nature, the best way to understand a legal proposition. To the point that Rubens, you helpfully say, well, what Ross is trying to remind us is that law is open to moral evaluation, and I know that Ross makes this point a number of times. My concern is that Ross also reminds us that pretty much everything we do is all the time open to moral evaluation, and indeed that's a key argument in some of his other analyses. So the question is not, is law open to moral evaluation? Is law apt to moral evaluation? But what is distinctive about law as opposed to, my students send me papers, I give them grades, which they're then not happy with, but my practice of grading papers is subject to moral evaluation. It's also subject to then certain internal norms of, I'm told I have to follow a certain grading curve. I'm told I should, make sure that the work is authoritatively that of the student and not artificial intelligence or something else. And there may be at times moral reasons for me to deviate from the norms of my practice. So everything we do is subject to moral evaluations, and many of the things we do are within a practice. You say, the law is its own practice, right? Law is its own practice. Faculty governance is its own practice. Teaching is its own practice. Friendship, to some extent, is its own practice, which has its own norms, but also subject to external norms. It's harder to come up with examples of, maybe moral reasons not to move the bishop, but put that aside. Most of our practices are self-contained, but yet potentially subject to conflict with morality, and sometimes must give way to morality, and sometimes will not give way to morality. Gilberto says, well, what about the legitimacy of the legal system? It's important, right? Well, you definitely want to know, is your legal system moral, just, good? But I think that's a different topic. In John Finnis's response to Leslie Green, he says, Leslie Green at one point says no one should only be a legal positivist. He should also have a theory of legal reasoning, should have a theory of legitimacy of the state, and so on. And Finnis says, you've cut yourself too narrow a path. Maybe, right? But, what makes a good legal system, a legitimate legal system, is a different question. And I think when we ask the question of what's the nature of legal normativity, I don't think the nature of legal normativity is or turns on whether the legal system as a whole is legitimate or the legal system as a whole is as just as it could be. And so I want to tie these points together. And I think Raws's line of objection that when you prescribe for other people, you are necessarily making a moral claim, because how else could you possibly justify to prescribe to other people? I think that is perhaps the hardest objection to overcome. But my answer would be that not merely as a psychological or sociological matter, but even as a conceptual matter, judges are acting in their normative role, in the discourse and the normative system of law. And they're saying, you have violated the Section 242, and Section 243A says that those who violate 242 shall be sentenced to 5 years in prison, and that is therefore what I have an obligation as a judge, obligated to apply the law, including sections 242 and 243, must do. Now, are there occasions where the judge should, for moral reasons, lie about the law, disobey the law? Perhaps, probably. Certainly, you think of the great evil systems of our time, of previous times of Nazi Germany, the Stalinist Russia, apartheid South Africa, where judges of good faith had to face the difficult moral decision of what to do. Right? And law is subject to moral evaluation, and every action you do as a lawyer, as a judge, as an advocate, inside or outside the law, is subject to moral evaluation. There may be moral reasons to disobey your obligation as a judge. But I think when judges say, I sentence you for 5 years for violating 242, they are simply acting within the normative system of the law as an official of that normative system. Just as, priests act in their role in their normative system. That gets us a little far afield. But again, I'm most grateful for your taking my work seriously, and if I haven't adequately responded to the objections, I do apologize.
We can have a Q&A session, right? Few minutes. Is that right with you?
A few minutes. I have been told long ago that one should not too long or too persistently stand between people in either lunch or free time, but
okay, well, maybe we have a few questions, and okay, first one, Danielle. I'm going to take, let's say, 3 questions in a row, and then you react, and let's say start with Danielle. Then your name is Guilherme. Anybody else? Okay, so Danielle and Guilherme. I would like to make a few comments too, but okay. I'm in a privileged position. I can do it later. Danielle, please.
Many thanks, Professor Biggs, for your paper. It is a really, really fun paper to read. It is really insightful. And just a small side note, I just felt vindicated by you some weeks ago because I was reading your piece about the whole metaphysical turn and why the metaphysical turn was not a mistake, but we're wasting too much energy on something that is not really important. I read that, it was like, yes, I've been vindicated. Well, no, my question, I'll try to
No, you have to stop there.
Well, my question is about something you say on pages 14 and 15 in the paper. And basically, from pages 14 to 15, when you're explaining your view that, well, legal normativity is sui generis, you say something like this. Well, the basic notion is more or less like this. Well, what the law provides us with are legal reasons, and the meaning or explanation of terms like legal obligation, legal right will come in some significant form from within legal discourses. So we have this on page 14. And here I have there's a first thing I would like to listen a bit more is, well, unless you are a really narrow-minded Kantian, you also will believe that the content and the more concrete content of moral propositions will also be somehow given by the context you are acting. If you are, well, if there's a Nazi on my door asking if I'm hiding Jews, well, maybe I should lie and say to the Nazi that I'm not hiding Jews, while in fact I am. And if I send my paper to Gilberto to read, and then Gilberto thinks that my paper is really bad, then he probably should tell me that. So even moral propositions depend on the context and depend on other things that are not strictly speaking moral for them to make any sense. So I would like to, on this point, what I would like you to listen a bit more is, why would this fact about legal propositions, that their content depends mostly on the legal domain, be an argument in favor of the sui generis view? And on page 15, you say that, well, to think that law and morality are the same thing is problematic in the face of our everyday experience, because law and morality often conflict. We have divergences between law and morality, and this might play a role in explaining why it's a bad idea to conflate law and morality. And my issue with this claim is more or less the following one. well, sure, law and morality conflict, but also morality has conflicts in itself. So if I make a promise to take my mother for grocery, and I see Gilberto, he's lying on the floor, almost dying, then there is prima facie a moral conflict, even though one that I can solve. And more or less the same thing goes about other conflicts between the law and morality. If there is a very, very unjust law, then maybe I should ignore the law and do whatever morality tells me to do. But also, there's no difference between those kinds of conflicts. So I was wondering, why would you think that this sort of conflict would also play a role in explaining why the sui generis view is the right way to go? So I think, I'm not sure if my questions were clear, but that's basically my 2 points on page 14 to 15. Basically, why those arguments actually play a role in the supporting your view. Thank you very much.
Thank you, Danielle. Professor Bix can react right now. I'll take your question later. Okay.
Thank you. I appreciate the remembering that I'm a very old person who doesn't have a good memory. There's a lot going on in your question. So, your first you mentioned Kant, and then you say when the Nazi comes to the door, you should lie to the Nazi about your whether you're hiding someone, and of course that's its own irony since Kant doesn't think you should, but Kant's an absolutist. Most of us aren't. All right, and part of the problem is the first part of your question depends on a whole category of moral philosophy that we can all talk about, though I have no particular expertise, which is what are the contours of moral rights and duties, and how do exceptions fit in, and there's a whole school of thought that morality is so detailed with its exceptions and possibilities that you don't even know until you answer the particular, the morality never conflicts. It just has very complicated borderlines. And I have nothing of special value to say on the topic. But I think what you're ultimately gets to is that, well, if morality is complicated and morality has conflicts and morality has exceptions, how are you telling us anything special by the fact that law and morality conflict? Well, of course, law also has its own little complications. Legal rules are defeasible in various direct and indirect ways. I mean, Ronald Dworkin's favorite example is under the will statute, you inherit unless you happen to be the person who killed the person you're trying to inherit from. And when the case came before the court, either, depending on how you want to characterize it, found an exception, created an exception, imposed an exception, and suddenly, you always inherit unless you happen to be the murderer, right? And in American and Anglo-American system, we have common law rules where the rules are developed by incremental decisions by judges who, will take a prior decision that say, in this situation, plaintiff always wins, and then the next court will say, well, plaintiff always wins unless plaintiff was reckless, right? So yeah, there are in the criminal law exceptions, exemptions, or mitigation for necessity or compulsion, and yeah, there are similar complicated structures. But nonetheless, I think besides the fact that pointing out that there are conflicts and exceptions within law and morality, the type of conflict between law and morality is maybe not different in kind, but it is phenomenologically different, right? The law tells me to do this, but it's deeply immoral. Morality tells me to do this, but it's against the law, right? And the answer to that is not, well, we'll get it before the judge and we'll find out there's an exception. Generally speaking, that's not the result of law morality conflicts. That legal system, John Austin said a long time ago. If you're found guilty of a capital offense and you go before the court and you say, but it's against the natural law, the court will ignore you and execute you. Right. So generally speaking, while there are internal to law and morality exceptions and exemptions and conflicts that each system resolves or doesn't in different ways, and people and experts disagree on how they do or should handle it, that doesn't negate the point that the type of conflicts between law and morality, remind us that they are not the same thing. I don't. You don't seem convinced, but that's okay. No one's ever convinced. So it'll come to you later.
We'll be back.
Yeah.
Yeah.
But let me just say in general, please, if you have comments or questions or want to follow up, my email is easy to find online. It's just bix@ulmn.edu. You can find it on my website. Please do feel free to follow up. As I said, this article hopefully has been put to bed, but these are issues I am writing about in other pieces or will write about in other pieces, and I do want your help to not do quite so poorly the next time.
All right. Thank you very much for the wonderful paper. And I would also like to thank the organizers for putting together this wonderful event. So I have like a quick, direct question that I think was already somewhat mentioned by Rubens and by Danielle to some extent. But the question is it that the law's claims to be exercising legitimate authority necessarily implies that a number of like specific legal statements regarding duties and obligations are also like normatively robust? So in other words, couldn't it be the case that legal statements about like duties are not robustly normative, and they are normative in the exact like formal sense that you mentioned, and you quote David Enoch as also claiming, but still like that the legal system as a whole necessarily claims legitimate authority above and beyond like the specific duty that you have with regards to an individual legal norm, an individual legal ruling, for instance. All right, thank you.
So what would that mean? If the claim of legitimate authority means something different from the status of every particular legal rule, right, duty, permission, what does it mean?
I mean, it could be that there is like this duty to like pay your taxes at the 27.5% like tax rate or something like that, right? And then you have just the kind of formal normativity that you mentioned and that David Enoch mentions. And it could be like that the claim that this specific norm is legitimate is false, or it isn't even being sincerely made by the authorities. But still, like it would be the case that the system as a whole claims legitimate authority somewhat. I'm not fully convinced that that's the case, that there could be this decoupling, but it's just something that I was like wondering when I was reading the paper and listening to the talk and the Q&A. It's like, well, is it indeed the fact that there is a necessary connection between the statements at the level of like legal obligations and legal duties and the systematic claims of the system?
Okay, so let me just say two things. One is, there's a whole literature on whether there is a presumptive, a prima facie moral obligation to obey the law, even in generally just legal systems. I mean, one of the things that's come up on that debate is that, it's no longer accepted by everyone that there is. Very prominent theorists, including Rawls, including M.B. Smith, and others, Simmons, William Edmondson, etc. The other thing that has developed in the debate is that the question, for a very long time, perhaps centuries, it was taken for granted that the government being legitimate and people having at least a presumptive moral obligation to obey the law were sort of two sides of the same coin. And now it's more people understand them as separate questions. So maybe what you're saying is we could have an assertion about whether our government is sufficiently legitimate, sufficiently moral, sufficiently just, that it has the moral right to use coercion to enforce its legal duties, right? Which can be, at least conceptually separate from the question of whether you and I have a moral obligation to obey the law. Right? So maybe that's the separation, one possible separation you're getting at. Beyond that, I'm still a little at sea of what it would mean to say the law claims legitimacy, but does not, but only claims formal, etiquette-like legitimacy for each of its individual rights and duties. I would want you to think about how to flesh that out, because at least this early in the day, based only on water rather than something stronger, I can't quite work it through.
Okay.
But please do follow up with an email later if you can develop the idea, because it could be very productive.
Thank you. I think I just want to follow, but it's not a question, it's just a reaction. I think there is always, when we're discussing in English, there is a difference between our languages and English. In English, we call law both the law, which we call direito, and the law, which is the statute. So, of course, we can accept the direito as a whole, but we can react to particular statutes and say, well, this doesn't fit either the situation, the law as a whole, and then we're going to question either the statute directly in court, saying this statute cannot survive within the system, or we can challenge the statute in particular cases. But then we have this difference. We are not challenging the direito. We are challenging that statute in particular in that case. So I think that's what's behind Guilherme's question, if I'm not mistaken. So you take the direito to be legitimate in a way, but not this particular statute or this provision of the university, something like that. That's one point. The other thing is, just to comment again, I think we'll come back to that in the following days, is that I think when I have my own reading of Ras, and contrary to Rubens, I'm more Rasian than he is. I think Ras is the best. I'll tell you something I say here, Professor Bix. My students know that. I say, Hart was like Moses. He led his people up to the Jordan. He said, there is the promised land, but he himself didn't get in there. But his followers are like Joshua. They said, okay, that's where we're going. So you have all these followers, his students, they go into the promised land, except for Ras, who I think is one of the best. Ras is in the middle of the Jordan. He says, should I really go over there? Or should I mean, what's my position in the positivist tradition? I want to keep it, but at the same time, he's kind of, that's my reading, he's kind of philosopher of action. So you cannot be a philosopher of action without suggesting there is a good and an end to your action, be it your personal action or be the action of a polity. So I think that's what makes him, at the same time, a very rich intellectual or scholar, and at the same time, he's criticized from both sides of the Jordan, let's say. He's criticized from both sides. And my final point would be is this: living under the law is actually a moral way of living. And so you have to if I take this idea, that's my idea, to live under the law is a way of moral living. It requires these prior ideas. I mean, and you used one good expression in your paper, says, in good faith. Am I in good faith? Well, being in good faith is a moral attitude to a role as a citizen, as a judge, or even as a player. We call a player who's in a soccer game or whatever. We say, well, he's got fair play. I mean, this just a comment. I think these are things that are coming up in the next stage. But if you want to say something, I don't want to tire you too much. So thank you.
I just want to say one thing. We're all here, law students, lawyers, researchers in law, and it's easy to we're on the law side, right? It's easy to think that law is a good thing, and but I think it's always useful to have a dose of the American legal realists, the Scandinavian legal realists, the Genoese legal realists, critical legal studies, your countrymen and occasional government minister, Professor Mangabera Unger, yeah, a little skepticism that maybe living in the law is not always to be on the right side. Robin West has a piece on her interpretation of the law and literature movement, that how there are great literary figures who tried to show that laws can sometimes, the legal official, the lawyer can be the judge can be the figure of, the use the Nietzschean term, ressentiment, the resentment. So I've lived under the law. The law has done well by me. So it's it's a little churlish of me to suggest criticism, but I'm just cautious about which side of the Jordan the law is.
Right. Okay. So thank you very much, Mr. Biggs. Thanks everybody who joined us here present in our room and in the virtual room in YouTube. Thanks Gilberto, who's out there, Rubens, Adiel, always, all of us. Thank you very much.